spinning routine at the circus. Keeping up with every development in Donald Trump's various legal entanglements demands a great deal of concentration and maneuverability. So let's spin the plates here together. Heads on a swivel, being very clear about which case is which. First, in New York tomorrow, former Trump attorney and fixer Michael Cohen will testify in Attorney General Letitia James's civil fraud trial into Trump's allegedly phony finances, for which he's already been found liable of fraud. After a delay because of a health issue, Michael Cohen, whose deposition was released publicly at the start of the trial, is expected to describe the ways in which Trump inflated his assets. Then there's the federal election interference case that's been brought by special counsel Jack Smith. Late Friday, Judge Tanya Chutkan agreed to temporarily lift her narrow gag order while Trump's lawyers appeal the narrow gag order. So what did Trump do? Well, he celebrated by doing precisely what he would otherwise have been barred from doing, by attacking, quote, deranged Jack Smith online by name and striking at the credibility of a potential witness in that trial. But perhaps the most astounding developments this weekend had to do with the other criminal election probe, the one in Fulton County, Georgia. We told you on Friday that Trump campaign legal advisor Kenneth Chesebro, a key figure in the fake elector scheme, became the third, count them, 1, 2, 3, third co-defendant in that case to plead guilty. Over the weekend, his lawyer insisted his client did not implicate his ex-boss. Watch that.
I want to make something clear. He did not implicate anyone else. He implicated himself in that particular charge. Someone asked me earlier, if you were Donald Trump, would you be worried? And I could personally, honestly answer no. And it's not that Mr. Chesebro is trying to protect Donald Trump or anyone else. I personally do not believe the state will call him to testify on their behalf.
And, of course, that's TBD, and they've all been charged as one criminal conspiracy. But you'll remember Sidney released the Kraken Powell. She's another co-defendant in the Fulton County case, another one who entered a guilty plea last week as well. Well, yesterday, as if on cue, Donald Trump pulled his classic I hardly knew her routine, suggesting via social media this, quote, Ms. Powell was not my attorney, it never was, end quote. Fascinating claim to make, given that Trump himself announced that Sidney Powell had joined his legal team in a November 2020 tweet there on your screen. We're back with Mary, Andrew, and Pete. Mary, where to start? It's a poo-poo platter of crimes and criming. Let's go with the Sidney Powell distance. I imagine that to charge everybody who Fani Willis decided to charge, keeping in mind that there were, I think, more than a dozen others who were not charged, there was some strength in the evidence of who she ended up choosing. What is your sense of the dissing of Sidney Powell, the distance being put between Trump and her in a public arena?
Well, as you indicated, this is par for the course for Trump. You know, you and other journalists have shown over the years that anytime something happens, he takes an opportunity to diss someone. Journalists can come up with a tweet or a social media post from 1, 2, 3, 4 years earlier that completely contradicts what he's saying now. So I don't think we can trust really anything that Mr. Trump ever puts in a social media post. Now, a lot of people have been talking about, doesn't this just make it impossible for him to rely on any kind of advice of counsel defense based on the advice that Ms. Powell might have provided to him when she was acting in some sort of capacity as a lawyer for the Trump campaign or for Trump himself. And I don't think, again, that his tweet alone, or I guess it's not a tweet, his social media post alone will answer that legal question. That's something that will be litigated if, in fact, he and his team seek to rely on advice of counsel defense, that counsel being Sidney Powell. There's also the possibility that prosecutors in Fulton County, Georgia, will seek to introduce some of the, testimony of Ms. Powell, or even other things that she might have communicated to Trump or his inner circle through other means. And, he may try to make an argument. This is, in fact, I'm speaking about when he finally goes to trial there. That trial date hasn't been set yet in Fulton County, Georgia. He may try to make an argument that that's privileged communication as well. And that's something that will be litigated at the time. So it's certainly, his statements are contrary to the showings that would need to be made to have either advice of counsel defense or an attorney-client privilege. But I don't think he's going to be, I don't think a judge is going to find that his attorneys and he are bound by what he said in social media when it comes to actually litigating any issues of privilege or advice of client. He has other reasons that those are weak defenses, including the crime fraud exception to attorney-client privilege and other matters. But again, I think we'll see litigation over these things.
And that's where Trump finds himself in the federal election interference case, testing the boundaries of any effort to narrowly tailor any sort of gag order. Andrew Weissmann, I wonder what you make of his conduct while Judge Tanya Chutkan stayed the narrowly tailored gag order there pending his appeal.
You know, Mary and I were talking about this, which is I'm going to be a little bit contrarian to the view, which is, oh, he's definitely going to violate a gag order and doesn't care, because I don't think he wants to go to jail. And so far, at least the state court judge has made it very clear that that is a possibility. And if you notice, he didn't violate it until he knew that it was stayed. So then he went ahead and said something that would have been a violation. So to me, this is I mean, it's deplorable, but it is rational, and it shows that he actually is focusing on what he can and cannot do. So I think that these orders from Judge Chutkan, from Judge Engoron, will have an effect. You know, remember that he's been given a wide swath of things that he can talk about. He can denigrate Joe Biden. He can denigrate the Democratic Party, the administration. He can talk about Mike Pence. And there's a lot of things that he can do, and he certainly will do. What these are really focused on is not sort of calling people out by name, and sort of exposing them to violence. So we'll see what the Court of Appeals does, but I actually think that this, if it stands, this will have a deterrent effect on the way he conducts himself pending trial.